Hi, everybody. It's Leslie with the New Mexico Small Business Development Center. And I want to welcome you to today's webinar. I have Ian Alden. He is an attorney here in New Mexico, and he's going to be telling us about operating agreements, bylaws, and shareholders agreements, and what all that means and how, I guess, to put it all together. So I want to remind you, if you have any questions, Ian's great about picking these questions up throughout the entire webinar. Any questions, type them into the Q&A. I'll turn it over to Ian.
Thanks so much, Leslie. It's good to be with you all this morning for another workshop. Today, we're going to be talking about the different kinds of documents that govern a company, whether that's an LLC or a corporation, how they fit together, and why they're important for avoiding conflicts with co-owners of companies, for example. So we're going to be taking a bit of a deep dive into what these different documents do and figuring out how we can make them work for you. As Leslie mentioned, I'm happy to take questions throughout the presentation. Please use the Q&A feature at the top of the screen. I really don't check the chat, but if you use the Q&A to submit your questions, I'm happy to take them as they come up or at the end of the presentation. If you want to save your questions to the end, please keep track of what slide you have questions about. You can see in the bottom right-hand corner the slide number. Just mark that down, and that way you know what we can refer back to. So a few things before we get started. There's a number of COVID-related links in here, some helpful resources for employers to look over how to maintain a COVID-safe workplace for starters, which is going to be very important as we all start coming back to work in the office. This is my first week back in my own office, and I'm sure a lot of other business owners are itching to get back there. So take note of these resources. They're very helpful, and yeah. So a few quick points. Your microphone should be muted by default, but if it's not, be sure to mute it. Make sure your Zoom ratio is set to fit window so that you can see the entirety of these slides that I'm showing you. Again, we'll be using the Q&A function. Write down the slide number if you're saving your questions to the end. Some upcoming workshops that you should be aware of, because there's a great number of them that are provided by the SBDC, a lot of very helpful resources for you and your business to further your own knowledge and further your business. We've got workshops coming up June 4th, 7th, 8th, and beyond. We've got a lot of things about online marketing, statistics that you want to keep track of. I'm giving one on Monday about smart ways to monetarily and non-monetarily reward and retain your key employees and executives. We've got series on contracts and social media presence. And moreover, the SBDC offers a lot of great resources like no-cost business counseling and loan application assistance. So be sure to check out their website and avail yourself of the great resources that the SBDC has to offer. So we're going to take this in steps. We're first going to talk about operating agreements for LLCs before going on to bylaws and shareholder agreements. We'll do a quick recap and comparison just so you can see this all in one place. And then we're going to talk about why they matter, dispute scenarios, and what they look like with versus without good documents in place. And I'll tell you some of those outcomes of those disputes might surprise you. So stay tuned to the end there. So first, we've got operating agreements. Now, operating agreements, they are the governing document for a limited liability company. When you make an LLC, one of the first things you should do after forming the LLC is to get a good operating agreement in place. There's a number of ways to do that. You can, of course, have a lawyer draft one. You can often find some resources online, whether they're templates or generators. There's a number of ways to get an operating agreement, but you typically want one that's really tailored to your business, because the operating agreement, at its core, it provides for how the company runs when it's up and running, and how the company eventually winds up and dissolves when it's done. It's those two things in a nutshell. And what that looks like under the hood, it's everything from voting rights, how issues are decided, how the company is managed on day to day, how profits and losses are allocated and distributed to the members. All kinds of different things go into this operating agreement. It's basically the governing document of the company. So if there's any questions about what happens in a particular circumstance, how do members interact with each other, what rights do members have against one another, that's what the operating agreement is for. It's a contract between the members of the LLC and the LLC itself. So the company is a party to the contract, as are all the members. All the members or owners of the LLC would sign off on the operating agreement. Without one, and keep in mind, you don't technically need one to have an LLC, but without an operating agreement, the state's default rules apply. Those default rules are written into the state's Limited Liability Company Act. They're somewhat old, very vague, and not at all tailored to anyone's situation. So we'll look at the end of this presentation, we'll look at how a dispute would play out with an operating agreement versus with those default rules. Again, it can get really interesting. In my own practice, I've dealt with a lot of disputes between members or owners of an LLC who didn't have an operating agreement. And it ended up being a research project for the attorneys on both sides of the dispute to figure out, okay, what do the state rules actually provide? And at the end of the day, no one came away from it happy. So it's a useful thing to have. Now, it begs the question, what should an operating agreement actually do? And the operating agreement should provide a lot of things. I mean, it can be a bulky document. They typically run around 30 pages when I draft them, because they contain everything about how the company runs and operates. So at a very minimum, they should specify what the LLC's purpose is, what its business purpose is. That might be clothing manufacturing and all other lawful purposes under the LLC Act. It might be real estate sales. The operating agreement should spell out what the company actually does. It's an important recital so that the courts, if it ever comes to litigation, the courts know what the company is actually made to do. Because again, all the members sign off on the operating agreement. So all the members are agreeing, this is the purpose of the company, this is what it does. Where will the LLC conduct business? Could be vague, could just be the state of New Mexico, County of Bernalillo. Oftentimes operating agreements will provide the business address. We're going to be doing business at this office space or other substitute spaces. It's a basic thing, but it's worth including. Where you get into the real meat and potatoes here, it's how decisions will be made. Operating agreements need to consider this. They need to consider, in a very holistic sense, how the LLC is going to be run. Oftentimes that takes a split approach where, maybe there's a manager appointed by the members who's going to run the day-to-day operations of the LLC. They get to make all the minute little decisions about, okay, what are we going to, how do we pay these bills? Are we going to pay these bills? Do we sign up for cable versus DSL internet? All the things that you don't really want to submit to the members and have a full vote on. Maybe the operating agreement vests those decisions in a manager. But then if the operating agreement does that and it provides for a manager to make these decisions, it has to spell out what decisions are reserved for the members. What decisions are too big, too consequential for the manager to decide on their own. These are things like signing a new lease for a long term, a year or more, buying real estate, selling real estate, entering into long-term contracts or franchise agreements, taking out huge loans or other forms of debts, selling the company, buying a new company. There's all kinds of things that you want to make sure that the members have a fair say in. And then from there, you have to decide, okay, the members are going to have a say in these decisions. How much of the membership needs to be on board with the decision for it to pass? There's usually a split threshold there where some basic decisions get to be made by a simple majority. let's say 50% plus one of the membership. But then there's some really consequential decisions like buying another company, selling this company, liquidating, etc., taking out a huge debts or mortgages that should be approved by a supermajority, whether that be 67%, 70%, or sometimes people want unanimous decisions where some of those big consequential choices need to be made by all of the members in unison with unanimous consent. The operating agreement needs to spell out all of this. And I'll tell you the default rules for the state. If you rely on the default rules and don't have an operating agreement, the default rule is just majority rule. A majority of the membership interest can decide on pretty much anything that isn't specifically granted to the manager. So, operating agreement, really handy for customizing these things. Some very big topics of dispute that I see over and over again. I've got two new ones this morning. Can a member voluntarily withdraw from the company? And that is to say, if you have a member, and again, a member is an owner of an LLC. If you have a member who's disgruntled, they want out, they want to just be able to walk away, can they just walk away from the company? You might be surprised to find that the answer is sometimes no, depending on the operating agreement. Sometimes yes, sometimes no. There are some valid reasons for not wanting a member to be able to walk away. For example, if there's a situation where the member is individually responsible for the LLC's debts, or if they're integral to the LLC, you don't want them to be able to just walk away on a dime. The operating agreement is where you can provide whether the member can just walk away and withdraw. If they can, how much will they be paid for their interests, if anything? Also, when will they be paid for their interests? Typically, when I do an operating agreement that allows for withdrawal, the member will be paid the fair market value of their interests over a period of 3 to 5 years to give the company the ability to do that without breaking the bank. The default rule in the state of New Mexico, if you don't have an operating agreement, is that a member can voluntarily withdraw at any time and be paid the fair market value for their interests up front, which means the company might have to take out a loan, or they might have to close up shop and liquidate to pay out that withdrawing member. You don't want to find yourself in the position of having to lose your business because one of the members wants to withdraw and the company is short on liquid cash. So that's something the operating agreement should provide for. Can a member sell their interest in the company to a third party? This is another big one. Typically, members of an LLC, especially a closely held LLC with only a few members, don't want some random third party coming in the place of one of the members. You don't want to have to accept someone you don't know and have never dealt with before. So typically, LLC operating agreements will provide either a member can't sell without the consent of the other members, or a member can sell, but the other members, or maybe even the company, have the right of first refusal where, let's say, a member wants to leave. They have a bona fide offer from a potential buyer. They provide that offer to the company or its members, and the company or its members can stand in the place of that buyer and buy the membership interests from the departing member under the same terms. That's a right of first refusal, and that's very common in operating agreements. It's not something that the default rules of the state typically, contemplate. So you want to protect your interests in the company and your ability to keep other people out with an operating agreement. Another big one that comes up in disputes: can a member be involuntarily removed from the company? A lot of people think that if you own the majority of an LLC, you can give minority members the boot for whatever reason just because you own the majority. That's rarely, if ever, the case. The default rules are very vague on this point, but operating agreements should provide for whether someone can just be given the boot. If someone can be given the boot, typically you're going to have to pay them out something, whether that's the book value or fair market value of their interests. This is one of the most fiercely litigated issues in LLCs is how can someone be involuntarily removed and what are they owed from the company? And so the operating agreement should spell this out with clarity, for one, to make sure that the members treat each other fairly. But for another reason, you want the operating agreement to provide this so that everyone understands going into the process what their rights are going to be, because that is going to prevent a lot of lawsuits or heated disputes. If everyone knows what their rights and obligations are, it's a lot harder for them to argue that, for example, they don't know or that it's wrong. If it's in the contract and they agree to it, as long as it's not unconscionable, the operating agreement is going to govern. So it's nice to have that clarity and certainty going into the process. Another thing the operating agreement should contemplate is, should a member be automatically dissociated, which means removed from the LLC? A lot of times the answer is yes. And I'll give you some examples right here. Bankruptcy, death, divorce, or a conviction of crimes of moral turpitude. In bankruptcy, if you have a member of your LLC declare bankruptcy and you don't have an automatic dissociation provision, or at least the right for the members to decide to kick the member out, the bankruptcy trustee is often going to stand in the place of the member. And that bankruptcy trustee, they have one priority, which is to maximize the recovery from the debtor's assets to satisfy the creditors. So they're going to be looking at that LLC membership interest and trying to figure out, can they sell it to a third party? Can they force the LLC members to buy that interest back? Or can they force the LLC to simply close up shop and liquidate? They're going to look at what option gives them the most chance of recovery, and they're going to take it. And so you want to beat them to the punch a lot of the time by automatically kicking out a member if they end up in a bankruptcy process. Typically, you're going to have to pay them the fair market value of the interest, which would then go to the bankruptcy estate. If you try and pay them less than the fair market value, the bankruptcy trustee will try and invalidate the dissociation, yada, yada. Point is, you don't want to be dealing with the bankruptcy trustee as a member. So the operating agreement should provide that. The default rules will not, but the operating agreement can and should. Similarly, if a member dies, that doesn't automatically dissociate them under the default rules necessarily, but the operating agreement can provide that they're automatically dissociated, which means that the estate of the member will get paid, again, typically the fair market value of their interests over time, but it means you don't have to deal with the personal representative or executor of the deceased member's estate, which again, you don't want to be dealing with people you don't know or people you don't think you can work with. That feeds right into divorce. If the membership interests are community property that gets split up between the member and their spouse, you don't want to be dealing with an ex-spouse. So there's another event. Conviction of crimes of moral turpitude. Moral turpitude can mean a lot of things, whether that's financial crimes of embezzlement or whether that's heinous crimes we don't need to talk about, but that would bring disrepute to the company. You want the ability to kick members out in those situations, and often you want it to be automatic. So, that's what the operating agreement provides. Another very fundamental thing is, how will profits and losses be handled? How will they be allocated to the members, and how will distributions happen? This is something that is very dependent on the tax status of the LLC. And so a good operating agreement needs to know and understand the tax status and work around it. Because an LLC can be taxed as just about anything. An LLC with multiple members is taxed by default as a partnership, but it can elect to be taxed as an S Corp or a C Corp. And the way the LLC operates under the hood is very, very, very different depending on the tax status. And so a good operating agreement should provide, for example, that if it's taxed as a partnership, the LLC members can have their allocations and distributions of profits and losses in whatever way they decide, as long as it has economic substance, meaning it has to be based in some kind of reality based on what the members are really doing for the company. You can't have a member who's a 1% member getting 50% of the profits, for example. That doesn't have economic substance. But otherwise, LLCs taxed as partnerships are very flexible. LLCs taxed as S corporations are not flexible at all. They need to make pro rata allocations and distributions based on the percentage ownership of each member. That's non-negotiable. And so this is where we get into the, you don't just need an operating agreement, you need a good operating agreement topic, because if you have an operating agreement for an LLC that would be taxed as a partnership and you use that operating agreement for an S corp type LLC, you can compromise the S corp election. The IRS would look at it and say, this isn't operating as an S corp, it's not following the rules. We're going to make it taxed as a C corp, which creates all kinds of headaches and extra taxation for the company and its owners. So, you know, the operating agreement should specifically address how profits and losses will be handled. It's very important. Moreover, the operating agreement should, with respect to distributions, say when they're going to be made, because a lot of operating agreements by default say, well, it's up to the members, or it's up to the managers, or the president, or someone to decide when the company will distribute its profits out. But keep in mind that with any LLC taxed as a pass-through entity, which means LLCs taxed as partnerships or S corps, the owners are allocated their respective share of the profits for tax purposes, and the owners have to pay taxes on that, regardless of whether the LLC pays them anything in distributions. So you don't want a situation as a minority member, and I've litigated this a handful of times. You don't want to be a minority member in an LLC where you're paying 10, 20, 30% of the taxes on the profits of the company, but you're not getting any distributions because the majority member has decided, I'm just not going to make distributions. The LLC will keep all of the money. That means that you're on the hook for taxes and you're never seeing any money from the company. So maybe you want the operating agreement to require periodic distributions once a month or once a quarter. Maybe at a minimum, you want the LLC to provide tax distributions, which means once a year, roundabouts, the LLC is going to pay out a distribution of the highest potential tax liability of the owners, minus any distributions already made in the previous year. You know, these are the things that no one thinks about. And if you don't think about it until you're a year or two into your LLC, it's too late. So really, I mean, it's not too late. You can still correct things going forward, but you could find yourself in one of these problem spots. So the operating agreement should figure this stuff out. And then lastly, how does the operating agreement get amended or replaced or superseded? When you need to change things, what's the process? Does it require unanimous consent of the members or just a majority or supermajority? That can get really thorny because all the members are technically supposed to sign the operating agreement. Whether or not they're ultimately required to by law, it's another matter, but it's good form for them to. So often you'll have unanimous consent required to change the operating agreement. But these are things you have to consider. Oh, sorry. Finally, how will disputes or disagreements between the members get resolved? Mediation, arbitration, litigation. It's good to have a dispute resolution process spelled out so that everyone knows what's going to happen. And then how will the company be wound up or liquidated? What's the process? Is there someone who's going to handle it? Will they use a third-party trustee or receiver? This can be a very basic provision, but it's important not to leave it out. So here's some examples. Keep in mind, I'm a contracts attorney. I draft these things all the time. So here's a few examples from a recent one that I did. This is just the basic declaration of an operating agreement. It says, you know, this is an operating agreement between the members. They're forming an LLC pursuant to our LLC Act. This is what this document is. It's basic preamble. It's pretty important so that there's no doubt that this is an operating agreement. You start looking at things like tax status. And again, like I said, these are very specific to each LLC. This operating agreement provides that it's taxed as a partnership. Everything that follows from this section 2.6 has to do with partnership type taxation and accounting. How are capital accounts managed? How are allocations and distributions handled? Things like that. I mean, it's a lot of nuts and bolts stuff that most folks just skim through. Even if you don't entirely understand it, it's still important to have it. And then stuff like this, like I was talking about, how are decisions made? Usually my operating agreements break things down into routine versus important matters. Important matters have anywhere from a 67% to a 100% requirement of consent of the members, so either supermajority or unanimity. And then the routine matters, it's greater than 50%. And then withdrawal, a lot of operating agreements like this don't let members just up and leave the company without the approval of the other members. And then there's some automatic events of dissociation where a member will just be kicked out. So that's operating agreements in a nutshell. They are dense, and I did them first because now I'm going to show you bylaws and shareholder agreements, which work in tandem to basically do what operating agreements do. Operating agreements are, like I said, they're bulky. Good ones are between 30 and 40 pages typically, and they kind of run the gamut. I mean, they're supposed to contemplate pretty much all of the governing mechanics of the LLC. Looking at bylaws, they're the governing document for a corporation. But just because they're the governing document for a corporation doesn't mean that they're basically operating agreements or that you could sub in an operating agreement for a corporation. I have seen people do that. I've seen people take an operating agreement and graft it onto a corporation, and the results are disastrous because the law around LLCs lets the LLC Act be superseded by operating agreements in a lot of ways. The LLC Act provides default rules for operating agreements, and if the operating, or for LLCs, and if the operating agreement has its own rules, the LLC Act will defer to the operating agreement. It's not like that for corporations. Corporations are much older entities, more formal. They've got a more formalistic structure and requirements under the law that can't be superseded by bylaws. They can't be replaced or overridden by bylaws. So bylaws provide a basic framework for corporations and corporate governance. They're meant to be abstract and constant. They don't change. They're required to be adopted by corporations formed in the state of New Mexico. Like I said, an LLC doesn't need an operating agreement. Corporations do need bylaws. They're required. They don't supersede the Corporations Act. They simply complement it by providing for things that the Corporations Act says the corporation needs to decide on. Things like voting, how directors are appointed, how officers are appointed, when meetings of the shareholders and directors happen, things like that. Shareholders typically don't sign the bylaws. Like I said, it's not the same as an LLC where every member signs the operating agreement. The bylaws and the Corporations Act generally, they assume that shareholders come and go because corporations, a lot of corporations are publicly traded entities, or they have small percentage of shares that change hands a lot. Shareholders are expected to come and go far more frequently than members of an LLC. And so shareholders don't sign the bylaws. They're still bound by them by virtue of owning shares, but they don't sign the bylaws. And that's important to understand because whereas an operating agreement is a contract between members in the LLC, bylaws are not a contract between shareholders. So at a minimum, bylaws should set out the time, place, and manner in which the annual meetings of the shareholders and the directors should occur. These meetings are required by law for corporations. So the bylaws are just saying, the law requires these, so they're going to be held on, in the first week of every new year, for example. You pick a date within that first week. The bylaws should define what shares are and what it means to be a shareholder. They should delineate classes of shares if you have more than one. S corps can only have one class of shares, but C corps can have many. They can have common and preferred shares, class A and class B, that do different things. So the bylaws should spell out what the different classes of shares are and what their respective rights are. They should provide for the election and removal of directors, how the directors are added, what their typical terms of office are, maybe 1 or 2 years at a time, and how they cycle in and out. The bylaws should establish a board of directors and define its responsibilities, what it's supposed to do. It should define key officer positions for the board, like the president, treasurer, secretary of the board, stuff like that, chairman of the board, etc., and what those officer positions do. They can optionally establish key officer roles for the corporation itself, like the chief executive officer, CFO, COO, etc. These are officers that are usually appointed or hired by the board. So sometimes this isn't provided in the bylaws, but the board itself writes up these officer descriptions, in which case, again, they're not part of the bylaws. They're just some internal board document that shows what these other officers are and do, and then the board goes out and hires them. So, it can be in the bylaws, but it doesn't have to be. The bylaws establish voting rights for the shareholders and the directors. The bylaws should declare the tax status of the corporation. Again, you've got C corps and S corps. The bylaws should provide for which. And if the bylaws are providing that it's an S corp, the bylaws should have some restrictions related to S corps. For example, prevent ineligible shareholders from owning shares. They should provide for winding up and liquidation of the corporation. Provide for the shareholders' rights to dividends or distributions of the company's profits, and provide policies and procedures for amending the bylaws. Again, the bylaws are largely static and unchanging. Most corporate clients that I have had their bylaws in place since the 80s or 90s. I mean, they don't change nearly as often as operating agreements do for an LLC. Now, it's important with bylaws to understand what they don't do, or at least what they shouldn't do. Now, bylaws are abstract documents. They don't change that often, but corporations have a lot of churn. They have a lot of turnover. Officers come and go, directors come and go. So the bylaws shouldn't name people, except, at the bottom, there's a signature block where the president and secretary sign the bylaws on behalf of the corporation. Their names are going to be there forever, but the bylaws shouldn't say, for example, so-and-so will be the president, so-and-so will be the treasurer, etc., because then you have to amend the bylaws every time your officers change. And that's complicated. Oftentimes bylaws are provided to the state, they're a matter of public record, so you really don't want to do that in bylaws. Bylaws shouldn't attempt to contradict the New Mexico Business Corporations Act. And I see this a lot with my clients where like, I know the Corporations Act provides that the shareholders have these rights and that the directors have these duties, but we want the bylaws to say differently, and you can't. The bylaws can't contradict the Corporations Act except in rare instances where the act defers to the bylaws. There are a few, but they're few and far between. So bylaws really, they're meant to work in harmony with the Corporations Act. They're not meant to supersede it the way an operating agreement does for an LLC. And finally, bylaws typically shouldn't create restrictions on the transfer of stock, because again, bylaws are largely unchanging. You can amend them, but it's a process, especially if you have a bunch of different shareholders, small shareholders. It gets really complicated to amend the bylaws. So you want to leave them in the abstract, and you typically don't want to create restrictions on the transfer of stock. Some exceptions are if you have what is now and will always be a closely held corporation, and that no matter who exceeds as a shareholder, you don't want them to be able to just transfer their stock without some kind of mechanism in place, then you can include it in the bylaws. But otherwise, those restrictions are typically included in the shareholders agreement, which we'll talk about in just a minute here. So bylaws shouldn't create those restrictions on the transfer of stock, and they shouldn't do a lot of these other things that end up being really personalized agreements between parties, that all ends up in the shareholders agreement. Now, some general examples of bylaws, this is kind of what they look like. The bylaws, some of the first things that they need to do, they need to create and establish the board of directors, because the directors are the top level management of the corporation. The directors are answerable only to the shareholders and law, but the shareholders are who the directors answer to. And then beneath the directors are officers like the CEO, CFO, COO, who answer to the board. So the first thing you do is establish the directors. And this is an example of how that works. Again, it's important for the bylaws to establish the tax treatment of the corporation. This one is taxed as a subchapter S corporation, which means that the very next thing I did with this is say can only have one class of stock, which is in keeping with IRS regulations for S corporations. You want these bylaws to work in tandem with the applicable law, the Corporations Act, IRS guidelines and regulations. You want them to line up and basically reiterate and restate what needs to be restated so that the shareholders understand what the situation is. So that's bylaws in a nutshell. If there's one takeaway from that section, it's that bylaws are very basic documents. They're meant to have the basic terms of governance and operation of the corporation. They're not meant to provide for complex agreements or relationships between the shareholders about, what they're individually going to do, or, how the corporation is going to be managed on more of a day-to-day level, things like that. For that sort of thing, we get into shareholder agreements. The shareholder agreements are a side agreement between shareholders of a corporation and really just the shareholders. Shareholder agreements rarely, if ever, bring in the corporation as a signer. The corporation usually isn't bound by the shareholders agreement, but the shareholders are. And so it's just a contract between themselves. They're by their nature less permissive than bylaws because they can't be more permissive. They can't permit something that the bylaws don't. And I'll give you an example here. If the bylaws themselves prohibit the transfer of shares without the consent of all the other shareholders, the shareholders agreement can't then say the bylaws notwithstanding, shareholders can sell their shares at will. It doesn't work. The bylaws are the preeminent governing document of the corporation. They trump the shareholder agreement every time. So just keep that in mind. They can't do something the bylaws don't permit, but they can forbid something that the bylaws don't. So for example, and very commonly, if the bylaws don't prohibit the transfer of shares of the corporation, but the shareholder agreement does, the shareholders are bound by the shareholder agreement not to transfer their shares without going through the approval process. So shareholder agreements are very commonly used for that reason, if nothing else, which is to set out the terms under which shareholders can get rid of their shares. Now, shareholder agreements can be, and they frequently are, amended or superseded as shareholders come and go, in part because they have to be. I mean, you can specify that the shareholder agreement applies to a shareholder's successors and assigns, people who take their shares after, whether that's through purchase or through inheritance. If a shareholder dies and their heir inherits their shares, you want their heir to be bound by the shareholder agreement. And so, that's typically provided in there. But all the same, when you get new shareholders who kind of want their own arrangement, maybe you've got new shareholders who aren't as experienced, they're not going to be the managers, they're not going to have the same rights as their predecessor, shareholder agreements can be amended or superseded and replaced. So keep that in mind. Shareholder agreements are not a matter of public record, whereas the bylaws are. This is another big reason why people use shareholder agreements, because anyone can go up to a public corporation and say, I want a copy of your bylaws. And under the Corporations Act, that's a matter of public record. The corporation has to disclose that. But shareholder agreements, again, are just a contract between private parties, between the shareholders. So they're not available for public view or access. So if you've got really complicated or possibly controversial provisions, maybe having to do with compensation of shareholders, um, or rights of shareholders, responsibilities, etc., those go into a shareholders agreement for privacy's sake. Now, again, they have many possible uses, but these, more than any other document I've talked about, really need to be customized for the company and for the shareholders. Because there's a lot of things that a lot of shareholder agreements do that you might not want in your own agreement. For example, they can create a right of first refusal that we talked about. If someone wants to sell their shares, the other shareholders get the first right to buy those shares. They can declare a manager or multiple managers for the corporation, spell out their duties, and even provide a salary or compensation for the manager. They can do a lot of things there. Sometimes when you get into compensation from the corporation, you have to rope the corporation in as a signer to the shareholder agreement. But again, not always. They can provide alternative dispute resolution processes like arbitration or mediation that often aren't includable in the corporation's bylaws, because the bylaws typically require that the corporation itself use dispute resolution mechanisms that are in keeping with the Corporations Act. But because a shareholder agreement is just a side contract between shareholders, that's one of the things that you can dictate, saying, the corporation has its own dispute resolution process, but we shareholders amongst ourselves agree to resolve our disputes informally through mediation or through arbitration instead of litigation, etc. It's there's a lot of customization to be done in the shareholders agreement. Another thing that, again, you often don't want publicly disclosed, maybe you've got some large shareholder, supermajority shareholder, and you are going to agree amongst the shareholders that they can name someone to the board of directors. The corporation bylaws, they provide how directors are elected, which is, you've got candidates, they get approved by the shareholders, etc. But then the shareholder agreement, it's a side agreement where the shareholders can say, okay, this is, we're going to elect them in compliance with bylaws, but this particular shareholder is going to put up the only candidate for that particular director position. Very common in shareholder agreements. The other thing that shareholder agreements do that bylaws typically don't is enjoin shareholders from engaging in competitive business ventures. Maybe you don't want shareholders, especially in a closely held corporation, to go work for another corporation or poach employees or contractors or other shareholders. And so that's all something you typically include in the shareholders agreement. These things are very flexible and very customizable. You don't want to just pull a template off the internet with these. If you're going to have a shareholder agreement, I highly recommend having a lawyer prepare it for you. They can also have tag along or drag along rights where if the majority owner wants to sell the corporation and the buyer wants to buy 100% of the shares, the minority owners also have to sell. That's something you can have in a shareholder agreement. You can have funding mechanisms where the shareholders are agreeing to contribute money to the corporation. And you can have standards of conduct, ethical, environmentally friendly business practices, etc., worked into the shareholder agreement that go above and beyond what the bylaws or the law might require. So you can do a lot with these things. Now, what they can't do, they can't automatically bind new shareholders. And by new, I do mean new. So, for example, if the corporation decides to issue new shares to someone who's buying in, someone pays the corporation $100,000 for brand new shares, that new shareholder won't be automatically bound by the shareholders agreement in place between the old shareholders. You might be able to require, as part of the terms of that new shareholder buying into the corporation, that they sign on to an amended shareholders agreement, but just know that it can't automatically do it to new shareholders. You're going to have to get them to sign on. Similarly, shareholders agreements typically won't bind the corporation. Sometimes you get the corporation to sign the shareholders agreement. Oftentimes you can't or don't want to. But even so, even if it does, the corporation's liability in a shareholders agreement is limited to breach of contract claims. If the corporation does something that violates the shareholders agreement but doesn't violate the bylaws or the Corporations Act, it's under the law permissible, even if it's a breach of contract. It doesn't constitute, for example, a breach of the corporation's duty to its shareholders under common law, like a duty of, well, there's a handful of them. But the point is, it gets really thorny when you try and bind a corporation to a shareholders agreement. So just keep that in mind. Here's some examples of a shareholders agreement. We're talking about restrictions on the transfer of shares. This is just a general restriction. The agreement would go on to say, for example, right of first refusal, etc. But shareholders agreements typically provide these kinds of restrictions on the transfer of stock. Right of first refusal, this is what one looks like. This is kind of the lead into it, where then you talk about, okay, same terms as the buyer, but with a longer payment term. Maybe if the buyer is offering $1 million, the corporation or its shareholders will pay $1 million, but over 5 years. Those sorts of things are common in shareholders agreements. Now, just to do a quick recap before I get into dispute scenarios. The operating agreement is a governing document for the LLC. It's very inclusive. It's basically the bylaws and shareholders agreement in one, which works because the LLC and the members all sign on to the operating agreement, typically. So it's a contract between and among them all. It includes all the basic stuff that the bylaws would have. Typically, it defines officers, or at least defines the management of the company, provides all the allocations and distributions, rights of first refusal, restrictions on transfer of stock, etc. I mean, it's the operating agreement has it all. The bylaws are the governing document for the corporation, but they're very limited and narrow in scope. They're abstract. They're not contracts between the shareholders, and they're very limited in what they can do with respect to the Corporations Act. The shareholders agreement is the everything else for a corporation. They basically fill in the blanks as to what an operating agreement would otherwise provide for the LLC. They're a private contract between and among the shareholders, and they kind of memorialize side agreements between those shareholders that go above and beyond what the bylaws do. So here's a little checklist I made. The bylaws, as you can see, they check most of these boxes, but it's a little misleading because it's in a very sort of limited way. They do some of these things. And then the shareholders agreements, they're typically more narrow in their focus. Shareholders agreements don't address the entire scope of how the corporation runs and operates, but they memorialize specific side agreements between the shareholders, typically with respect to voting rights, election of officers and directors, etc., restrictions on sale and transfer. And then on the right-hand column, operating agreements, they do just about everything. You notice there's a little X in operating agreements when I say declare officers, directors, or managers. By declare, I mean name them. You typically don't name your officers or directors or managers in the operating agreement. Sometimes you do. Like I say at the bottom, these aren't hard and fast rules for the most part. They're just guidelines, but operating agreements typically won't name the officers or directors. That's done in resolution of the company after the fact. So we've got 10 minutes left. And again, feel free to ask your questions at any time. But I'm going to go through some quick dispute scenarios so that we can see what this really looks like with versus without these documents. Because, I can give you all of the nuts and bolts of what these documents do, but you might be shaking your head and saying, well, okay, I get that, but at the end of the day, what's the real risk if I don't deal with all of this and I just leave it alone? And so here's some of the risks. Example one, you've got 3 owners of an LLC, Bill, Ted, and Frank. It's got a good operating agreement in place. And two of the three owners want to expand the business in what's a pretty risky proposition. Let's say they're a restaurant business and they're just scraping by right now, and they want to open up a new location, which would require a 5-year lease, huge capital investment, and maybe even require some kind of personal guarantee of the owners. Two of the three owners want to. Bill and Ted, they want to do this expansion. Frank is risk averse. He worries the company will become overextended, putting his existing investment at risk. He doesn't want to expand right now. He wants to kind of, ride these waters out for a while and then judge things in a little bit. The operating agreement provides that decisions involving new leases or expenditures over 50 grand be decided by a supermajority of membership interests, which the operating agreement defines as 70%. Because two of the three owners only have 66.6% of the interests, the proposal fails. They don't have the 70% required to approve the expansion. Now, follow up with that, the members aren't happy with each other. Bill and Ted don't like Frank. Frank doesn't like Bill and Ted. They've decided that they want out. I say Bill at the bottom, pretend I said Frank. Frank can carry on as a member if he wants to, or he can withdraw from the company, as provided in the operating agreement, with the company paying him out over a period of time, let's say 3 years at fair market value for his interests. Alternatively, the operating agreement lets him sell his interests to a third party, giving the other members a right of first refusal. But there's a lot of mechanisms in here for a disgruntled member, whether that's Bill, Ted, or Frank, it doesn't really matter. The point is the operating agreement provides for a member to be able to get out in a number of different ways, and all the members knew that going in, so they've got no right to complain now when one member wants to exercise their rights under the operating agreement. It gives you clarity, and in the immediate sense, it protected Frank's interests. His investment, it prevented the company from doing something he really wasn't comfortable with. But now look at that same example without an operating agreement. Same thing, they're each 1/3 owners. Two of the three want to expand and one does not, fearing that the company will be overextended. The default rule in New Mexico under the LLC Act, if there's no operating agreement, it provides that a simple majority of the members will be required to make decisions not specifically vested in a manager. So a simple majority is greater than 50%. Two of the three members have more than 50% of the ownership interests, so they can approve this expansion over Frank's objections. Now, Frank still has some rights, or Frank is, in this case, wants out instead of maybe Bill, who wanted to expand. So, Frank, as the aggrieved party, can carry on as a member, or he can withdraw from the company and receive a payout of the fair market value of his interest, which the company would have to pay at once. So the company doesn't have the right to pay that over time. Suddenly the company, if it wasn't overextended before, it certainly is now, because it's going to expand and it has to pay Frank upfront for his interests. So the company loses here as well. But one thing Frank might not be able to do, and in fact he can't, is sell his interest to a third party unless all the other members consent to that sale. So as you can see here, the operating agreement provides a very different outcome than the default rules under the LLC Act. And so, if you're Frank in this situation, or if you're Bill, you're probably wanting that operating agreement, especially if you're Frank in this case. But, like I said, if Frank just chooses to up and leave, it puts the company in a bind without the operating agreement. So a good operating agreement is important for everyone. It protects everyone in the end. Here's another example, and this is one that I litigated. Well, not litigated, it was a dispute resolution thing, but it came across my desk a few months ago. Lisa and Janet each own 50% of the shares of NewCo, an S corporation in the state of New Mexico. Lisa wants out, and she's found a buyer, a friend who's very wealthy and an investor, but this friend lives in France and is a citizen of France. She's what the tax law in the United States calls a non-resident alien. The IRS prohibits non-resident aliens from owning shares of an S corp, and any transfer of shares of an S corp to a non-resident alien automatically terminates the S corp election, making it a C corp with double taxation, a bunch of other bad consequences. The bylaws in this example prohibit the transfer or accession of a non-eligible shareholder. So does the shareholder agreement. So the sale fails. Lisa can't sell, Renee can't buy, the company remains an S corp. The bylaws and the shareholders agreement protected Janet, the other owner, from bad tax consequences. Without those documents, there's nothing prohibiting that sale. So the sale succeeds, all of a sudden the S corp election is terminated. Renee becomes a shareholder. The S corp election is terminated. Janet, as the remaining owner, all of a sudden owns a C corp with double taxation, a bunch of other complicated tax scenarios that require complete rework, really under the hood of the way the corporation operates. And that is out of Janet's hands because nothing contractually prohibited it. So you can see where good bylaws and a shareholders agreement protect the shareholders from these undesired consequences. And so those are a few examples, but I'm telling you now, very common, I would say a substantial majority of the dispute resolution cases that come across my desk, and a lot of which get referred to our litigation team, have to do with companies that did not have good operating agreement, bylaws, or shareholders agreement. So it's really protecting your long-term investment to have these things. And so one of the best things I can advise you to do is work with knowledgeable professionals who can figure out your unique needs and come up with something that really works for you. And so a great first step here is to reach out to the SBDC. Like I said, they offer no-cost business counseling services. They've got a great wealth of folks they can refer you to if you need an attorney, for example, to help you with this. They've got a great network of resources. They can point you in the right direction for sure. So, if you have questions about this or anything else, really, I'd encourage you to reach out to your local SBDC liaison or go to the website and set up a counseling appointment, because the sooner you do this, even if you've already got an existing company and you just want to improve things going forward, it's never too late to make these changes in a way that's going to work for your company and its owners. Any questions, anything for the Q&A? Or if you just want to raise your hand, we can let you talk. I'm happy to answer any questions you might have.
We do not have any questions at this time, and I want to thank you, Ian, for giving us great information as always. And I thank you for reminding everyone to visit nmsbdc.org for any kind of business resources that you may need for you and your business. And I'd like to thank everyone for attending today. And you guys have a great day.
Thank you all.